Right. Good afternoon, everyone. Thank you so much for joining a primer on open meetings laws. I am Niquelle Allen, the director of the Office of Open Government. We are an office within the Board of Ethics and Government Accountability, charged with enforcing the Open Meetings Act and providing advice on the Freedom of Information Act. This is part of our open meeting training series. We wanted to do something a little different today and to give you some background on the Open Meetings Act. So we'll be going over that. And I hope that you enjoy this new training, new-ish training that we have today. So our agenda is as follows. Introduction. I will just give a brief introduction of the Office of Open Government and BEGA. Then I will get into the history of our open meetings laws in the United States. Then I'll go over the DC Open Meetings Act history, and I will conclude with some cases on the open meetings laws within the US. So introduction. Oh, and I will say that if wanted, these slides will be available. We'll also be making sure to post the recording for those who were not able to attend if you want to share with your colleagues. And all that information is on will be on open-dc.gov, our website. So as I said earlier, I am the Director of Open Government of the Office of Open Government, which is an office within the Board of Ethics and Government Accountability, or BEGA, as we're called, and most of you all know us from this space or also from ethics. BEGA as an agency was created in response to a need for a more robust and independent body to oversee ethics and government accountability within the district. And as we'll discuss in this program today, usually when you get movement in this body of law, it is because the public demands it. And the establishment of BEGA was part of a broader effort to improve ethical standards of accountability within DC government. And the DC Board of Ethics and Government Accountability Establishment and Comprehensive Ethics Reform Amendment Act of 2011, which became effective on April 27th of 2012, was again in response to a public outcry and need for more accountability in the district. So BEGA plays a key role in promoting open government practice through the Office of Open Government, which we refer to as OOG. And we do government-wide enforcement of the Open Meetings Act, and we monitor agency compliance with FOIA or the Freedom of Information Act. We issue binding opinions, advisory opinions regarding the OMA when compliance issues arise. We can also bring a lawsuit in DC Superior Court to enforce Open Meetings Act provisions. And as I mentioned, BEGA is also the primary ethics enforcement agency for the District of Columbia government, and BEGA is responsible for investigating alleged ethics violations and conducting mandatory ethics training. So let me get into the history of open meetings laws. So most of you are familiar with this famous DC picture, which we'll get into later. But again, when the public outcry comes out for transparency, the laws change. So we're going to go way back to the 1800s. That's when we first see open meetings laws being passed in the United States. The earliest open meetings laws really just applied to certain entities that needed to meet in public. More comprehensive open meetings laws followed. Kansas was one of the first to enact an open meetings law regarding its school board in 1895. Michigan identified an open meetings law passed in 1895 that required public city council meetings, and we have the case here. Oklahoma enacted a law governing the meetings of county commissioners in 1897. Utah's very first law was concerning the governance of city councils, and it was passed in 1898. And the law and the court said the city council, quote, shall sit with open doors and keep a journal of its own proceedings. So we see the concept of openness has long roots in the United States. Florida enacted its first open meeting law in 1905. This law was actually in effect until 2011, until it was superseded by their more comprehensive open meetings law. So speaking of which, Alabama is the state that can lay claim to enacting the first comprehensive open meetings law. And when I say comprehensive, I mean that the open meetings law is applicable to multiple public entities, not just a singular entity as we discussed with the first 1, 2, 3, 4, 5 states. Um, so Alabama enacted its laws in 1915, and until 1950 was the only state with comprehensive open meetings law. This Alabama open meetings law was essentially a statement of principles without the features of modern open meetings laws. And it was in effect, actually, this one until 2005 when it was repealed and replaced by the Alabama Open Meetings Act. By 1959, 20 states had comprehensive open meetings laws. But as we will see, after 1976, all states had open meetings laws. These state laws were referred to as sunshine laws, open door laws, right to know laws, and open meetings act. So now we'll talk about Watergate. Most people in the district are familiar with the Watergate, and in the United States are, but it happened here in our jurisdiction. The Watergate scandal was a major political scandal in the U.S. It involved the administration of President Nixon. It began with a break-in at the Democratic National Committee headquarters in the Watergate Hotel and Office Complex in 1972. The scandal escalated as former President Nixon and his aides engaged in a cover-up of their involvement in the burglary and other illegal activities, ultimately leading to President Nixon's resignation in 1974, 51 years ago. So I have a quote here that really goes to what was going on during that time. This was really a shock to the conscience for Americans that this could happen. Probably not so much now, but then it was certainly shocking. So the quote is, "A decade ago, revelations of secret abuse of official power shocked this nation and seared in our minds a lesson vital to the health of a democratic polity. Government should conduct the public's business in public. In the Sunshine Act, Congress moved to ensure that those in government do not forget that they are above all accountable to the people of this nation." So that's really the foundation for why we have open meetings laws and the other plethora of transparency laws in the district government and in the US. The idea behind it, again, is to inspire confidence in government and to keep government officials from backroom dealing and other things that keep the public from having confidence in its government and its government officials. So, though many open meetings laws were enacted before Watergate, most state laws were enacted or strengthened in 1976 because of the public's dismay over the extensive corruption and abuse of power at the highest levels of the federal government. Former Chief Justice Earl Warren opined the following in an ABA Journal article in 1974. "If anything is to be learned from our present difficulties, comprehensively known as Watergate, it is we must open our public affairs to the scrutiny on every level of government." So as practitioners, we know that the Open Meetings Act is not always uh, convenient for our government officials or public bodies to follow, but it is necessary, again, because we have this history in the United States of corruption and putting things into the light of public view, we hope inspires accountability and keeps the government officials from acting in ways that are corrupt and that do not follow the law or the spirit of the law. So Watergate scandal led to stronger open meetings laws through three ways. And the first is congressional action. So the scandal severely undermined public trust in our government institutions, especially on a federal level. It highlighted how closed door decisions, secret meetings, and a lack of transparency allowed illegal and unethical behavior to flourish without public scrutiny. I think someone may need to mute their line. I'm hearing something. So please mute your line if you're unmuted and not me. So in response to Watergate, there was a bipartisan push to institute laws to prevent abuses of power, to increase transparency in the government, and ensure public participation in government affairs by opening doors. And that's a key component to the open meetings laws. So here in the district, although we have public comment periods, we don't necessarily allow the public to intervene in the proceedings, but they can see the proceedings. So Congress, on the federal side, passed the Government and Sunshine Act in 1976. This law is still in effect. This law required federal agencies to hold meetings in public when deliberating on official business. The act was passed to increase public confidence in government by allowing citizens to observe the decision-making processes of federal agencies. It ensures that the government business is conducted in a transparent manner. The act generally requires that all meetings of multi-member federal agencies be open to the public. So I have a link here, which you'll be able to access through this presentation. Now, Watergate also led to state level reforms, as I mentioned earlier. The first was the enhancement and enactment and strengthening of the open meetings laws throughout the states. So all 50 states and DC enacted open meetings laws known as sunshine laws by 1976. DC's law, as you will discuss earlier, was actually enacted in 1973 with the Home Rule Act. These laws mandate that government bodies conduct their meetings in public, allowing citizens in the media, important the media, to attend and observe the decision-making processes. The goal was to prevent government bodies from making decisions behind closed doors, a major concern raised by the Watergate scandal. And that's kind of the principle too behind our Open Meetings Act here in the district. We don't have our government officials to make decisions unless, as we have discussed in our trainings, there are exemptions that permit them to go into a closed session. So again, that is so the public can observe the deliberation, the talks, all the things that happen in government that will let the people know how their tax dollars are being spent and why they're being spent that way. The open meetings laws on the state level also mandated transparencies. So these laws generally require government entities, as in DC, to give advance notice of meetings, including the time, place, and agenda, and in many cases mandate a record of what transpired at a meeting be published afterwards. So again, here in the district, we do require certain records be published after the meeting and records be kept. Focus on citizen participation and understanding. This is the principle behind open meetings laws as articulated in the Oklahoma Supreme Court decision in the Oklahoma Association of Municipal Attorneys versus State, and that was in the Supreme Court of Oklahoma in 1976. So it is to ensure that citizens are informed about government actions and decisions that affect their lives. So the impetus again behind all these transparency laws are the citizens. Money's tight, and we are having to spend taxes. We spend all different types of taxes. So we do have the right as citizens to know how our funds are being expended, what our government officials are doing. So Watergate also led to what we call the Sunshine Movement in government. This is the third outcome. So the Sunshine Movement in government refers to a period of time where there was increased legislative action focused on government transparency and openness. Laws passed in the Watergate period have transformed, among other things, the federal budget process, government practices for protecting individuals' personal information, and oversight of the intelligence community. While these reform efforts have not been uniformly successful, they reflect the resolve of the policymakers of that era, the Watergate era, who had a broad understanding of the abuses that needed to be addressed and who were willing to take broad actions to address them. That's key. In addition to open meetings laws, several key transparency laws were enacted or strengthened during this time. The first, which our office deals with, is the Freedom of Information Act. In 1974, Congress overrode a presidential veto to strengthen FOIA, providing new tools for the public and the media to access the executive branch information. The Federal Advisory Committee Act of 1972, this law, enacted before Nixon's resignation, sets the rules for federal advisory committees to ensure their advice is objective and accessible to the public. And last, the Ethics in Government Act of 1978. This act required financial disclosure by executive and judicial branch officials and created the Federal Office of Government Ethics. So now let's turn to the district. I see there, I don't know if there's any questions in the chat or not. But if you all have any questions, or if you need to slow down, or even if you want to make a comment, you can do so in the chat, or come off mute and say, "Hey, Director Allen, I have something to say," and please interject yourself into this conversation, because we all are government officials and open government enthusiasts, and that's why we're here. So, all right, so let's move on to DC's open meetings laws. So we have two, the Sunshine Act and the Open Meetings Act. The Sunshine Act was first. It was part of the Home Rule Act. Is Section 742 of the Home Rule Act. This is a picture of the actual Home Rule Act, the text of which will be on the next slide. So the Sunshine Act in DC is in DC Official Code Section 1-207.42A. It requires that all meetings of government entities, including the council, be open to the public when official action is taken. No official action is effective unless taken at the public meeting. It also speaks to records. It requires that a written transcription be kept for all DC government meetings and shall be made available to the public during normal business hours of the district government. Copies of written transcripts or copies of such transcripts shall be available upon request to the public at reasonable cost. So this law is still in effect. It has a private right of action. So if it's a meeting violates the Sunshine Act, you as a citizen or a citizen can bring an action in DC Superior Court under the Sunshine Act. The Sunshine Act, as you see, was not a comprehensive open meetings law. Some openness was expected of public bodies, but there was not a legal framework like our current law guaranteeing that meetings would be open to the public and agencies would be held accountable for opening their meetings. So advocacy groups here in DC criticize the district government for its lack of transparency and public access to its meetings. A lot of this was going on around 2010 when the DC Open Meetings Act of 2010 came to the DC Council. It was in response to growing concerns about transparency and accountability in district government. Law 181315, the Open Meetings Act of 2010, was introduced in the council and assigned bill number 181716, which was referred to the then Committee on Government Operations and in the Environment. The bill was adopted on first and second reading on December 7th, 2010, and on December 21st, 2010, respectively. It was signed by the mayor on January 19th, 2011, and assigned Act Number 18700 and transmitted to both houses of Congress for its review. DC Law 181350 became effective on March 31st, 2011, and then you had the DC Open Meetings Act. So this chart here shows you the differences between the two bodies of law. Again, under the Open Meetings Act, all meetings are public unless it falls into an exemption that permits the public body to have a closed session of a meeting. This is on the right side of the chart. Public body meetings covered are specifically defined as a forum of members assembled to consider, conduct, and advise on public business. In contrast, the Sunshine Act, which is very general, and it says all meetings at which official action are taken are open to the public. There are no notice requirements in the Sunshine Act, but it requires the public have access to the meetings. As you all know, the OMA requires public bodies to issue a notice of meeting no less than 48 hours or 2 business days prior to the meeting, whichever is greater. The Sunshine Act requires transcripts. The OMA requires all meetings to be recorded by audio or videotape. If not feasible, then the meetings must be accompanied by detailed meeting minutes. I think that was a switch of words in my editing, and I'll fix that before I put these out. The Sunshine Act and Open Meetings Act both infer that citizens may bring a lawsuit under the Sunshine Act. The OMA does not provide a public right of action. That's why this office, the Office of Open Government, exists. We enforce the provisions of the legislation, but there is no private right of action under the OMA. So now we're going to move on to the cases. And so these are cases in other jurisdictions or recent cases. I thought it was valuable to kind of go over what's going on in the litigation space to give clarity to our open meetings laws. Here in the district, the Office of Open Government, as I mentioned earlier, may bring a lawsuit. We've only brought one. Here, our public bodies have been very good about working with us to come into compliance, so litigation has not been necessary. But in other jurisdictions, this is not the case. So we'll go over the controversies that are existing in other jurisdictions and how they were resolved regarding open meetings laws. So the first case is North Carolina Citizens for Transparent Government Incorporated et al. Be the Village of Pinehurst et al. Hopefully we got some golfers or golf enthusiasts who can appreciate Pinehurst. So the issue here was whether email discussions amount to a public meeting. So I have a question for you all, and please put yes or no in the chat. In the District of Columbia, can public bodies meet via email? And I'll give a minute or so for you to put your answer in the chat. Hopefully I'll see some participation here. Uh-oh, my light went out. We're conserving energy here in the district. All right, thank you all for answering. And if you answered no, you are correct. A public body cannot conduct meetings via email under the Open Meetings Act in the District of Columbia. Our law specifically says that. DC Official Code Section 2-577C, email exchanges between members of the public body shall not constitute an electronic meeting. All right, thank you all for participating, and you all got it right. So let's move on to the case. So the facts of the case. This lawsuit alleged that Pinehurst, North Carolina officials broke the state's open meetings laws in 2021 by conducting business via email. Former Pinehurst Village City Council member Kevin Drum and his group, the NC Citizens for Transparent Government, accused the Pinehurst Village City Council of using email to avoid North Carolina's open meetings requirements. which are actually similar to the districts. The legal disputes stem from events that started in September 20, 2021. During a closed session, three council members raised concerns about Drum and a colleague. The discussion focused on conversations with the chief of police, Moore County legislators, aggressive emails to business owners, and other behaviors that the council members believe violated the village ethics policy, according to the North Carolina Court of Appeals opinion. Between that meeting and another meeting on October 12, 2021, other council members and top staff exchanged emails about Drum and his colleagues' conduct. Additional emails followed between October 12th and October 20 and an October 26th meeting of the body. The emails included a draft motion for censure. No censure vote ever happened. Lost his reelection bid and formed his citizen group in February 2022. Drum and his group filed suit against city officials in May 2022. The lawsuit sought declaratory and injunctive relief for violations of the North Carolina Open Meetings Law alleged to have occurred at the September 20th special meeting called during the email communications occurring between that time, as the Court of Appeals of North Carolina explained. At issue here is whether the emails, this is how North Carolina viewed it, were a simultaneous communication between a majority of the council members. The question of whether the email exchange is a form of communication by which no official meeting can be conducted has not been directly answered in North Carolina court. So unlike DC, North Carolina was vague on whether an email can constitute a meeting. So the court said in reviewing the state legislature's use of the simultaneous communication in statute, email is not considered a simultaneous communication subject to the Open Meetings Act requirements, but rather a work product subject to public records requests, which is interesting. The court goes on to talk about other jurisdictions. They talked about Virginia, Pennsylvania, and California, who have a simultaneity test. The holdings of this jurisdiction, as we look at the district, are not binding on the North Carolina court. The North Carolina court found the reasoning in Virginia, Pennsylvania, and California to be instructive and persuasive. The judge who wrote the opinion here focused on the nature of the exchanges between the mayor and other council members and the village manager and attorney. So key here, and what the holding is, a council member who generates 2 emails containing 7 sentences of less than 90 words over the course of 5 days is not engaging in simultaneous communication, conducting hearings, participating in deliberations, or voting upon otherwise transacting public business. When limited communication takes place hours or days apart, it does not constitute a simultaneous communication. So this court did not find an Open Meetings Act violation because of this email. And that makes a lot of sense. Again, given the time that had passed, I think that our public body members should have the ability to send each other emails and that not be considered a meeting. So I think the North Carolina court fell on the right side of the law here. And I would like to point out, just kind of as a general practice pointer, a lot of the time when you see these cases, and the next 2 that I'll talk about, it is usually because the public body has done something that a member of the public or here a former public body member does not like. So they try to get the public body on kind of a technicality that they didn't follow procedures. And as we'll see in our next cases, courts can invalidate actions of public bodies when they do not follow the rules. So that's why sometimes plaintiffs will come in against the city to challenge public bodies based on violations of the Open Meetings Act, because what they're trying to get at is to change the decision that was reached. So those of you on this webinar who are advising public bodies, that is really one of the reasons why they should do their very best to participate in meetings that are following the Open Meetings Act, because we don't want them to be pulled into litigation from the Sunshine Act, or Open Meetings Act, or otherwise, because their decisions are looking to be invalidated because they did not follow the rules. So the next case talks about legal advice in the closed session. I have another question for you all, and this is an easy one, I think. Please put yes or no in the chat. In the District of Columbia, does the presence of legal counsel alone justify a closed meeting? I'll give you all a few minutes to put your answers in the chat. Hopefully, if you've snoozed off, that'll help you wake up. I hope I'm not putting you all to sleep. But I see somebody coming in, some questions coming in. No, one person doesn't know. That's okay. That's what we're here for. No. Okay, great. Thank you all for participating and answering. And you are correct if you said no. The public body must actually be receiving legal advice. Here's the Open Meetings Act provision in the district. DC Official Code Section 2-575B permits closure to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body, or to approve settlement agreements, provided that upon request, the public body may decide to waive the privilege. And here is the answer. Nothing herein shall be construed to permit a public body to close a meeting that will be otherwise open merely because the attorney for the public body is a participant. So in DC, you have to actually be receiving legal advice. So we're going to explore this issue in Wayne Gray et al. Versus Dickson County. This is a Tennessee case. I'm staying in the South, a lot going on in the South. They fight down there. So this was a consolidated appeal, meaning there were more than one matter. In the case of Wayne Gray et al. Versus Dickson County, Tennessee. The court examined a citizen's challenge to the approval process of a settlement agreement between Dickson County and Titan Partners, LLC. The petitioners claimed they were entitled to more notice regarding the discussion of a settlement at the Planning County Commission meetings, and alleged improper use of executive sessions, violating the Tennessee Open Meetings Act. The trial court ruled in favor of the commission's finding no violations, and the appellate court affirmed the decision, agreeing there was no breach of the Open Meetings Act in Tennessee. So this case regarded the Dickson County Planning Commission's approval and subsequent denial of a site plan for the construction and operation of a fuel terminal. A nonprofit and two Dickson County residents are the plaintiffs. They argued that the Planning Commission acted in violation of the Tennessee Open Meetings Act when it held an unpublicized meeting and initially approved the site plan. Thereafter, at the next Planning Commission meeting, the Planning Commission overturned its prior approval of the project. After the denial, Titan Partners filed lawsuits against Dickson County. The Dickson County Commissioners and Counsel for Titan Partners engaged in non-public executive sessions regarding the litigation brought by Titan Partners. The plaintiff alleged that executive sessions were improperly utilized to discuss the settlement agreement in violation of the Tennessee Open Meetings Act. The Planning Commission held its regularly scheduled public meeting, which was live streamed on the Dickson County's YouTube channel, and public notice was given for that meeting, including an agenda, but the public agenda did not include or mention any settlement agreement or the project development. Now, in Tennessee, as I mentioned earlier, and this is the reason why folks sue, if a meeting is conducted in violation of the Tennessee Open Meetings Act, actions taken at that meeting shall be void and of no effect. provided that this nullification of actions taken at such meetings shall not apply to any commitment otherwise legal affecting the public debt of the entity concerned. So here, these plaintiffs were looking to invalidate an action that happened because, we could call it a technicality, because they violated the Tennessee Open Meetings Act. So on to the discussions that they had about the settlement. Excuse me. The court determined that the discussions between a public body and its attorney concerning pending litigation are not subject to the Tennessee Open Meetings Act. But they did say this exception is narrow, similar to the district. Clients may provide counsel with facts and information. This is a quote regarding the lawsuit, and counsel may advise them about the legal ramification of those facts. However, once any discussion whatsoever begins among the members of the public body regarding what action to be taken based upon advice from counsel, whether it be settlement or otherwise, such discussion shall be open to the public. So basically, you can talk to an attorney can give you advice, but once you receive that advice and you start deliberating in Tennessee, you need to do that deliberation in public. The court noted that the petitioners only proffered speculation, though, as the content of the executive sessions during which the lawyers met with commissioners to discuss Titan Partners lawsuits. There was no evidence, affidavits, deposition testimony, or otherwise of this use of the executive sessions or any indication that impermissible deliberations occurred. So here, the plaintiffs needed to provide the court with more evidence of what happened in the closed meeting. So since there was not evidence on the record, the court found a violation of the Tennessee Open Meetings Act. So just a practice pointer for here with the Office of Open Government. So one of the things that we do if there's a violation is that we do, I would call a light investigation. We give the public body opportunity to respond to the allegations, but we do collect light evidence. And what we would like to know is what actually happened, so we can request the closed meeting, so we can view the closed meetings. And that helps us to know and understand what happened and whether or not an actual violation occurred. But that is something that we need to present to be able to say a body violated the OMA in a closed session. So the court here again, they didn't get to the meat of it because there wasn't evidence for them to do so. All right, so we'll move on to the next and final case, which is Varga versus St. Paris Village Council. And this is a discussion of employment in a closed session. So here's another yes or no question. Our last one, please put your answers in the chat. In the District of Columbia, if a public body discusses an employment matter related to a public official or any official, may they meet in closed session? Please put your answer in the chat if you know. If you don't know, that's okay. All right, I do see a message. It's a private one. Let's see, Joycelyn, do you want me to answer this privately or share it with the group? Let me know in the chat. And yes, I see we have all of our answers. And the answer is yes, the public body may close the meeting on employment matters. DC Official Code Section 2-575B permits meeting closure to discuss the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal or resignation of government appointees, officials, employees, or of a public charter school personnel where the public body is the Board of Trustees of the public charter school. All right, hopefully I can find your question again. Give me 1 second. Okay, is there an OMA reporter, AKA court reporter, that records the meeting and the OMA minutes releasable? So what we recommend, what you must do for a closed session is to record it. The means you have flexibility by how you record a closed session, but it must be recorded because, right now we have Zoom, WebEx, Teams, and other means that you're able to record the video of your meeting. You can record audio. Um, but within the closed meeting, those minutes and those recordings are not released to the public. Those are kept private. And that's a function of the Open Meetings Act, that you do not have to release them, but you do have to keep those records. All right. I hope that answers the question. If not, please let me know, but put it in the general chat so our attorneys who are monitoring the chat can also provide additional information. I saw a raised hand. You could please come off the phone.
Thanks. You mentioned that we're not allowed to, or we don't have to post the meetings or the recordings of the meetings. Um, and
Of the
what
closed meetings.
of the oh, of closed meetings, but we do have to post of open meetings.
Yes.
Oh, okay. Well, does a transcript of that public open meeting meet the letter of
Yes.
the rule? Okay. Thank you. Like a written transcript. Okay.
Yes.
Thank you.
I mean, again, the idea is to make sure the public knows what's happening.
Sure.
So that's, again, the idea behind that.
Okay.
But if there's a video available, we do like those videos now. I think the public has come to kind of expect that, and we also just now we're talking about it, need to also be mindful of folks who visual and hearing impaired. I know budgets are tight, but we do like to make the attempt to make sure all of our records are accessible.
Got it. Thank you.
You're welcome. All right, so let's move on to our last case. Varga v. St. Parish Village Council. This is an Ohio case, so this one is up north. They have problems up north too, as we know. uh, so this is regarding a police chief. So when a Champaign County village police chief requested a public hearing to contest her termination, the village council violated state law by going into closed door session to discuss firing her, according to Supreme Court of Ohio. So as we discussed earlier, the rule's a little different in Ohio. If you're an elected official or a public official, you can request that um, the session be public. That kind of makes sense if you were, for example, an elected police chief or appointed by the mayor. You may want to kind of have the public have the opportunity to view the deliberation about your employment. The village council conducted several hearings in public session to hear witnesses and review evidence, but entered into an executive session to deliberate on Chief Vargas' fate, which would be okay in DC. Council members emerged from a closed-door discussion and cast a vote to remove Barker from the position. The Supreme Court found the Ohio Open Meetings Act, coupled with a state law outlining the process for disciplining the village police chief, entitled St. Paris Police Chief Erica Barga to have a full hearing process conducted in an open public meeting. She challenged the attempt by a mayor in 2020 to fire her for subordination and neglect of duty. So again, in this third case, you don't like an outcome, we're going to look at procedure. So as I stated before, the Ohio Open Meetings Law, which is RC 12122G1, permits a closed meeting to consider, similar to our language, to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official, or investigation of charges or complaints against a public employee, official, licensee, or regulated individual unless the public employee, official, licensee, or regulated individual requests a public hearing. The Supreme Court of Ohio cited the exception that allows public bodies to discuss certain issues in private, including employee termination, unless the public employee requests a public hearing. The court explained that if the public employee makes such a request, that means the entire process, including deliberations, must be open. So the court said here, Barger requested a public hearing, yet the village council chose to consider charges against her in private. In doing so, it violated the terms of the plain meaning of the Open Meetings Act in Ohio. The decision reversed a Second Circuit appeals ruling which sided with the village. The court invalidated Vargas' termination and remanded the matter to the village council to conduct hearings in compliance with the law. Oops, I went too far. So last takeaways. We have reached the end of the presentation. So the takeaways from this, again, thank you for participating and thank you for being here. Is just to remind you the need for public trust in government is the reason that we have open meetings laws. These open meetings law appeared in the U.S. in the late 1890s. The Watergate scandal provided the impetus for the Sunshine Movement that created our government transparency law nationwide, including strengthened open meetings law. So the government that you see on television that operates openly most of the time, we hope, is as a result of what happened in the 70s. In 2010, local government scandals and issues here in the district created a public outcry for accountability, which led to the creation of my agency, BEGA, and adoption of the Comprehensive Open Meetings Act in the District of Columbia. And lastly, public meetings protect the public, so follow the Open Meetings Act when conducting those meetings. We said email discussions in DC are not public body meetings, and make sure that your public body uses the open meetings exemptions properly and provides the required notice to the public about those exemptions. So we've reached the end of the presentation. Thank you all for your participation and attendance. I'd like to thank my Open Meetings Act and Open Government staff, our enforcers who are here today. Louis Neal is our chief counsel. Joan Lelma is our attorney advisor. She handles issues with education entities. So if you are advising one of those, Joan is your person. Anthony Skirbo, who is our FOIA expert. He is our attorney here and our FOIA officer for BEGA. And I have to also mention Joan is our records officer for BEGA. And Brandon Lewis, who has become our OMA guru. He is an attorney here who can help you as well. I can't see if we have our interns on, that we have welcome to interns here at BEGA. And if you are here online, welcome and thank you for the training. So that concludes the training. I will open it up if there are any additional questions. Please feel free to ask them at this time or go enjoy the rest of your day. Please stay cool. And again, thank you for your commitment to openness and transparency in government in the District of Columbia. All right, I don't hear that there are any questions. I'll ask my folks, are there any questions in the chat?
There are not.
All right, well, hopefully that means I gave you a comprehensive overview and we got everything. But again, thank you all for being here and we will see you soon. Training coordinator, do we know our next training? It should be next month. We have another Open Meetings Act training. We're also, if you're interested, we're having FOIA trainings come up. So we'll send you all the notices for that. But again, thanks for participating. And Anthony, do we know our next?
I don't have the date for the next OMA, but we will be sending out the FOIA webinar series. We'll be sending out to all the FOIA officers. So if you haven't been getting emails from us, or if you're not sure, please do send to the OpenGov office email your email address and identify yourself. in your agency as a FOIA officer, and we'll make sure that you get the invite.
All right. Thank you, Anthony. Wonderful. All right. Well, signing off. Thank you, everyone. Have a great day.